Sanibonani, Dumelang, Abusheni, Inhlikani, Imadambula Manene. Good morning, good afternoon, and good evening. My name is Sophia Butomi Mburi Yakachabalala, and welcome back to Second Chances with Sophia V. If it's the first time that you're coming to our channel, welcome, and welcome. May I bring it to your attention that this is actually part 2 of the topic around child maintenance. If you have not yet watched part 1, I would urge you to go and watch it. On that video, we particularly discuss the process that one would have to undergo when it comes to applying for child maintenance. Things to consider such as who can be sued for maintenance, up to what age you can expect to maintain a child, and most importantly, the actual process that you will actually go under. In a nutshell, the before process that you would have to do and how to best prepare yourself before you go on court or you go to court. Now, this video today, I will be discussing that you've gone through the whole application process, summons have been issued, and it is the court date. What do, what to expect, and how can you best prepare yourself? But before I go into further details, please let's take a short left to my disclaimer. Quick disclaimer, I'm not a lawyer, attorney, or any law profession. I speak purely from a point of experience, and this video is not intended to be used as formal legal advice. Now go back to the video and enjoy. The Child Maintenance Court is there to act as a voice on behalf of the child. It takes into account the expenses and the commitment of both parents without compromising the financial needs of the child. Should you have any access issues pertaining to the child, maybe there are quarrels between the two of you, all of those things do not come into effect when it comes to the maintenance court. If you are having any access issues, that is a different court altogether, and I would urge you to look further into family court and still continue to pay maintenance for your child, because that can come back and affect you in future. I would urge you to do further research so that you do not find yourself at the wrong end of the law. Let me give you a practical walkthrough of what your day at the court may possibly look like. And what better way to do that than to give you my own personal experience of how my day looked when I had to appear in court. So we personally went to Johannesburg Children's Magistrate Court, and we were given a date and time to appear to the court. Basically, I think we were given in an early morning time. I think it was 8 o'clock. And on the day when we arrived there, I actually found that in the building that we went in, there was a designated area whereby all the parents were seated. What that meant is that we all had to sit inside the building, but outside of the court, waiting for your case number to be called. So basically, I needed to take a full day's leave because I did not know what time my case would be called in. So it was case after case being called in, and people spent different number of minutes or hours when they went into the room that they went into based on that special case. Eventually, when the time did come and our case was called in, we actually walked into a small office. In that office, it was just myself, the father of my child, and a representative or someone that was working there at the court. That person, I do not know what their position is called. However, they did play the role of being a mediator and being a third person. I do know that they are not an attorney, they are not a lawyer, nor are they a judge. I'm not quite sure about the exact designation, but I do know that they were well equipped to be able to assist us. When we first walked into that room, our file was already on the table, and the J101 form that we filled in previously was also put forth to us to review once again. When we sat down, we with the mediator, basically she went through the rights of the child again, and they also went through our rights and responsibilities as parents. And some of the rights included being told that we do have a right to either represent ourselves, seek private representation, or seek representation that will be provided by the government. On that day, we seek to represent ourselves, so therefore we could be able to continue. Since I was the one who filed for maintenance, I was asked how much I actually put forth to be considered, or how much I considered would be fair as a contribution by the father of my child on a month-to-month basis. And I was also asked whether he accepts the amount or not. This particular question to me is very important, because I need you to understand that when you go to court, you are not going there to be bullied. Fair processes are being put there to make sure that the best interests of the child are put forward, and the court acts as the voice for the child. At that point in time, the first step, we were in an office. We had not yet gone into an actual court. However, if there's a different terminology for that office, I would very much appreciate it if someone has detailed knowledge, if they could clarify. Nonetheless, should there be no dispute between the two of you and you agree on the amount, then it should be a fairly quick process, because by then you'll be given a form to sign, and then you each given a copy, then you go about your life. That was not exactly my case. He did not agree with the amount, so the next step, we needed to move on to the next step. I was expected to present the evidence that I had to back up all the expenses pertaining to the child that I had put on the J101 form. By me presenting the receipts and whatever support that I had, the mediator went through the receipt line by line to make sure that indeed everything that is listed there is fair and is a need for the child according to their age at that point in time. And once that whole process is done, also in between them going through the receipt, sometimes the mediator would ask you to consider removing certain items from the form, even though you do have support for them, because they would not be considered as necessities. For example, maybe your child does 10 extramural activities. So yes, it is important for a child to have some sort of extramural activities should you be able to afford them, but it must be done so in a fair manner that both of you can afford. It is no longer a necessity after a certain threshold, I believe. I would assume, I believe, or however you would view it. So basically, they are not just going to take and accept everything that you have put in. Now you go into a negotiation type of a situation. They will also then take my they also took my pay slip to look at how much I earn. They looked at my expenses, and they did the same process with the father of my child. So even with both of us, while they were going through our expenses, they definitely considered if you have other children or other people that you are currently maintaining, but then they also would determine certain people with certain situations. They needed further clarity as to why you are maintaining those people, and it is based on situation to situation as to what they might deem or who they might consider as your dependent. But for each and every single person, you would need to have provided an ID certificate, yes, and all the other details that they would have presented you with guidance from the J101 form. So even going through both our expenses, they would advise that maybe you can this expense that you currently have, that you say you incur on a month-on-month basis, it is a luxury and you can live without it. Maybe you can consider moving this amount towards the financial needs of the child. For example, if you are maybe staying in an estate and you are also paying insurance for you are still also paying insurance for your television, they might put forward a defense saying that it is having an insurance is a luxury since you already stay in a secured estate. So those are the kind of things that that will be happening. So when you get there, it is not a bully type of a situation, it is a negotiation. In negotiation, in order to determine the fair amount that will be required from each party so that it can cover the needs of the child. Once that whole negotiation and the back and forth, you've removed and added things onto the form, you've removed and added things towards your individual expenses, then the mediator will then come up with the amount that they believe is a fair amount. Now it is either both parties agree on that amount, or they don't. When you agree on that amount, basically the first step for them would be to split the expenses 50-50 and say, if, for example, if the child's expenses are 100 rand and they say each parent needs to contribute 50 rands and 50 rands. After they've done the first part, then they will consider which parents earn a higher amount, then take away a portion of a percentage from the one parent and put it to the other one, so that the one who earns the highest takes on the bigger cut or the bigger portion of it. So should you agree on that, once again you will sign on the agreement form, and you will go on, you will be given copies, and you go on with your life. However, should you not be in agreement still after the mediator has gone through this whole process with you, and you feel like the amount that is being put forth is not being fair to you, the next step would be to go and see, you now go to court, to the actual courtroom, to see the judge on the exact same day. I believe now this will depend on region to region on how things actually operate, but in our case this whole process took place in one day. So when we moved from the one consulting office, we needed now to go outside and sit in front of the court again and queue until our case was called in. When we went into the court, once again our rights were read to us as to the different options of representative that we have, and should you decide or choose that you are going to represent yourself, then the case is able to go forward. Should you decide that you seek external consultation, it is within your right. However, the judge is also able to say, let me first hear your case, and I will be able to determine if indeed you do need other representatives, so that we can see if we can solve this, we cannot sort it out quicker. Now, should you decide that you are going forward with the case on that day, once again, the mediator that you saw earlier on would have presented their support and their recommendation to the judge. The judge will go through the form, and you will have to plead your case all over again. Both parties will bring forward all the support, all the evidence, and all the things. Basically, you are going through the discussion all over again, and finally the judge will decide the way forward and conclude the case. After that process has been done, basically you will sign the forms, but it will also be explained to you that you do have the right to appeal the decision that was made. I'm not quite sure the length or what the process requires for you to appeal that decision. However, it is an option. I just needed to put it out there that you can appeal whatever decision that is made by the one judge. On the very same, the best part, what I love about going through the maintenance court route, is that going forward they will explain to both of you that what are the consequences of non-compliant. What will happen if one of you default, if you default on the payment? You no longer have to call the other parent and constantly fight with them, because now you have a legally binding document. There are actions that are steps that the law can take against you, such as issuing a warrant of arrest, attaching any assets that you might have. Yes, your car, your houses, they might be attached in the court of law. And or thirdly, they might garnish your salary, meaning that they take your money directly from the employer. The same way you have any other deductions, the money will come directly for that, and it will reflect on your payslip. I don't know if you wanted to get to that, but I would assume you don't. So please, let's just do right by our children. Another important point that I should highlight is that should your financial situation change, you are allowed to go back to the court and let them know. Should you become unemployed at any point in time, do not just stop paying. Maintenance and leave it at that, because now you will be non-compliant. Rather, go back to court and communicate your change in situation, and they will adjust or amend your contribution accordingly. I'm well aware that there are other people, sadly, there are other parents that would rather resign from work due to having a maintenance order against them so that they wouldn't have to pay. I've said this before and I'm going to say it again. Just by virtue of you being unemployed does not mean that the rights of a child falls away. You would still be expected to contribute. And for me, and to a certain extent, your pension can be withheld. You cannot claim there can be steps that can be taken to freeze a certain portion or a certain amount of your pension, should you be claiming them, so that it can contribute to the future needs of the child. Basically, that's all it is, to say that the future claims that the child was going to have, then they hold your pension. So I would advise you to think very deep and to think very deep and hard about that, should you want to resign purely for that reason only. So should your situation change, and also you need to constantly go back to the maintenance court for the amount to be adjusted. Should an order be put forth while the child maybe is still an infant, obviously by a certain point in time in their life, maybe when they are going to high school, their needs would have changed by then. So you would need the court to adjust those amounts for you accordingly. And also, should your dependents change and maybe you have more children, you have more responsibilities in your plate, you can go back and ask for the amount to be considered, and you go through the same process so that the amount can be changed. And also, by going back and forth, going back to the court, maybe a situation has changed. This time around, the one parent was earning higher, and the next time the other parent is now earning higher. The percentage contribution can change. So over the years, the money does not necessarily stay consistent. That amount can be changed according to the child's need and the circumstances of the parents at that particular point in time. I don't think I can ever cover each and every single corner that there is when it comes to this whole process, but I do hope that whatever experience of mine that I went through, the information that I've shared, will shed some light and will contribute positively into your lives somehow, one way or the other. So yes, this is where I will end it for now. And please, I really love to hear from you. So please do leave a comment on the comment section below. Share the video. You know the statistics by now. You know that someone out there, there is a high chance of someone on your timeline or someone in your circle needing this information than not. So please do like, share, subscribe, leave a comment, and yes, join the family. Let's subscribe. Until next time, nimeranza yonkwenu.